Every day in the USA, people find themselves in court.
On the record in State of Michigan versus Larry Hiram O'Toole, 2103419 FY and 2200242 FY.
Assistant Public Defender Joseph Hardy on behalf of Mr. O'Toole.
And are you Larry O'Toole?
Yeah, I'm O'Toole. It is pronounced O'Toole.
O'Toole, got it. All right, Mr. O'Toole, what I have here is I have two felony complaints that I need to arraign you on. I'll do them in chronological order, I guess. First, I have a felony complaint that alleges that on or about October 20th of 2021 at 1215 East Michigan Avenue in the city of Lansing, count 1, aggravated indecent exposure, that you did knowingly make an open or indecent exposure of your person while fondling your genitals, pubic area, buttocks, or breasts. That is a high court misdemeanor punishable by up to 2 years in prison and or $2,000. This is a Tier 1 Sex Offender Registration Act if the victim is a minor, Tier 2 offense if you have a prior conviction for a Tier 1 offense, and a Tier 3 offense if you have a prior conviction for a Tier 2 offense. Count 2, attempted criminal sexual conduct in the 4th degree, that you did attempt to commit following listed offense, and in the attempt did act toward the commission of that offense, but failed in the perpetration or were prevented in the execution thereof, engage in sexual contact with another person, Cynthia Whittington, using force or coercion to accomplish the sexual contact. This is a misdemeanor punishable by up to 1 year in jail and or $1,000. Upon conviction of an attempt felony, the court shall order law enforcement to collect a DNA identification profiling sample. This is also a Sex Offender Registration Act offense. This is a Tier 1 offense if this, under the Sex Offender Registration Act, if the victim is 18 years or older. It is a Tier 2 offense if you have a prior conviction for a Tier 1 offense. It is a Tier 2 offense if the victim was between 13 to 17 years of age inclusive. It is a Tier 3 offense if the victim was under 13 years and you were the defendant, you were 17 years or older. It is a Tier 3 offense if you have a prior conviction for a Tier 2 offense. Take notice pursuant to Public Health Code upon bind over to circuit court or recorder's court, the district court shall order the defendant to be tested for sexually transmitted infection, hepatitis B infection, and for the presence of HIV or antibody to HIV if the judge determines there's reason to believe that the violation involves sexual penetration or exposure to body fluid of the defendant. If the district judge determines the testing is not required upon conviction, the court must order the defendant to be tested. Do you understand these two charges and the possible penalties in this case?
No, because I was locked up here on 2021, and the charges weren't those charges. They just gave me no charges and stuff. It was assault as an officer.
So the offense was dated October 2021, and they authorized the complaint December of 2021. There's no, I took care of it for this particular file. You can ask an attorney to look into whether there was another file involving the same case around that time that was disposed of. But today, my only question is, do you understand you're accused of aggravated indecent exposure and attempted CSC in the 4th degree?
Understand what you're saying.
Okay. And you understand that the possible penalties are 2 years in prison for count 1 and 1 year in jail for count 2.
Yes, so, yeah.
I'm sorry, what did you say?
Yeah, I guess so, yeah.
Okay, now I have another complaint here. This one's dated, it says November 4 of 2021. It says, on or about November 4 of 2021 at 900 Long Boulevard, City of Lansing, Ingham County, count 1, resisting or obstructing a police officer, that you did assault, batter, wound, resist, obstruct, oppose, or endanger Officer Melinda Hutchings, a police officer of the Lansing Police Department that you knew or had reason to know was performing her duties. That's a felony punishable by 2 years and or $2,000. A consecutive sentence may be imposed if the assault was committed in a place of confinement or for another violation arising out of the same transaction. Count 2 is trespass, that you did remain without lawful authority to remain on the lands or premises of Daniel Okoka after being notified to depart therefrom by Daniel Okoka, who was the occupant of said lands or premises, misdemeanor 30 days and or $250 in fines. Do you understand the charges and the possible penalties in that case?
Yes.
You have the right to have an attorney in each of these files. If you cannot afford an attorney, we can see if the public defender will represent you. You have the right to have a trial that could be by jury. You have the right to remain silent. Anything you say orally or in writing will be used against you. You have the right to have an attorney present with you during any questioning by law enforcement. You understand these rights so far, sir?
Yeah.
Are you requesting a public defender to assist you?
No, I'll get a lawyer.
Okay, I can mark down that you're going to retain an attorney, but you don't know who that is at this moment?
Not at the moment.
All right, well, I'm gonna give you some court dates, so the timeframes are going to be very fast. You're going to have to act quickly. Since you have felony charges, you have the right to have a preliminary examination. Preliminary exam is a day where the government must bring some evidence to demonstrate probable cause to believe that the felonies occurred and probable cause to believe that you're the person who committed these felonies. Before you have your preliminary exam, you will have a probable cause conference. That's a day where you, your lawyer, and the prosecutor make sure that you have all the evidence and information you need to be ready for preliminary exam. Your probable cause conference will be March 21st at 9 a.m. with Judge Ward. And then your preliminary exam will be March 28 at 8:30 a.m. with Judge Ward. Now that first date on March 21st can be done by video conferencing like we're doing now. But if you can't video conference, don't know how, your phone's not working, you should come in person. That second date, the preliminary exam, because evidence and testimony may be presented, you are absolutely required to show up in person on March 28th. Sir, they gave me an address for you on Long Boulevard. It's apartment 754. Is that a valid address for you right now? Or is the Grand Rapids address, they gave me your address?
No, it's the Grand Rapids.
Use the Grand Rapids? Okay, I will put that in both files. Hold on a second here. All right, based on a review of your criminal record, the charges in these cases, but also considering the age of the charges, I will set a $3,000 personal recognizance bond in the first file, which is 3419, and a $1,000 personal recognizance bond in the second file, which is file 242. The conditions of your release include you are do not leave the state without permission from the court. Do not commit any crimes. You must show up for your court dates. You must notify the court in writing if you change your address or a telephone number. That's important because we need to be able to reach you. You must report to pretrial services within 48 hours of your release. You should have a brochure there with a phone number to report to them. They monitor people on felony bond. Do not use alcohol, marijuana, or illegal controlled substances. Do not possess or purchase a firearm or a dangerous weapon. Do not engage in harassing, intimidating, stalking, or threatening behaviors. Do not assault, harass, intimidate, beat, molest, wound, or threaten Cynthia Whittington.
Who's Cynthia? I don't even know who Cynthia is. That's what I'm saying. Y'all just put a new charge.
She's the person who accused you. That's what you need to know. She
I'm just saying, I'll be honest, I'll
saying
speak my mind,
don't have contact with her. Stop.
I don't even
have
know who the fuck
contact.
is Cynthia. Like, we just saying.
Well, then it should be easy for you to follow my order, right? You're not to have any contact with her. You're not to be within 2,000 feet of where she lives, works, or goes to school. I don't know.
It's just,
Okay, I'm gonna just change the bond to cash surety because he's trying to walk out in the middle of me talking and being
I'm just saying, like,
disrespectful.
I'm being honest with you. I'm not being disrespected. You know, it's a new
No,
charge.
you just walked away in the middle of me speaking to you. That was disrespectful. Speak
I'm
again,
right
Mr.
here, right?
Ottole. I'm trying to give you the conditions of your release, so you can either listen and be released, or you can give me a hard time and I can just hold you in jail. What would you prefer?
I'll listen.
Okay. All right. You're not to have any contact with Miss Whittington. If you don't know her, it should be pretty easy to have no contact. If you violate an order of no contact, you could be arrested without a warrant. Your bond could be revoked. You could be in contempt of court, for which you face up to $7,500 in fines plus 93 days in jail, separate and apart from that which you already face. This includes a bar on you being within 2,000 feet of where she lives, works, or goes to school. Understand the conditions of your release?
Yeah.
Okay. All right, so make sure you contact pretrial services right away and you show up for your court dates, March 21st, March 28th. Understand?
All right.
All right. Bye, Mr. Otole.